Good morning, members. We have a quorum, and this is appointed time. I call to order the meeting. Let's invite the administration to come in. At the previous meeting, we have already scrutinized all the clauses on the Chinese version of the bill. In today's meeting, we will deal with the government's replies and the proposed amendments. Let's wait for the administration. We have received 6 sets of public submissions altogether. The government's consolidated reply is set out in paper CB-17443. When the officials are seated, I will invite Ms. Zhang, Deputy Secretary, to walk us through the consolidated reply on public submission. Members, if you have questions, please press the button. Thank you, Chairman. Good morning, members. Now, we have received 6 written submissions from the public, most of which were supportive of our amendments. Some suggestions were made by the public. We have boiled them down to several points. First, on the naming of the housing ordinance. Some members of the public think that we should change the name of the ordinance to Public Rental Housing Ordinance. Now, the ordinance seeks to establish provisions for the functions and establishments of the housing authority. Now, under the housing authority, besides PRH, for rents, there are also subsidized housing for sales. So we think the present name is more appropriate for that purpose. And also some members of the public consider that the marking scheme for estate management enforcement should also make part of the schedule. Now, the marking scheme's purpose is to enhance the management and environmental hygiene of public housing units. The demerit items are very different from those serious tenancy abuse. These include putting up laundry in public places and accumulation of stale water leading to mosquito infestation. We think it is not appropriate to criminalize these behaviors. And the existing demerit system is already effective. Provided that 16 points have been demerited in 2 years' time, a notice to quit will be issued, and the eligibility of the tenants for applying for PRH again will be suspended for 5 years. So we think there are sufficient deterrents already. The third suggestion is on scrutinizing the information provided by tenants or applicants. Now, at present, on submission of application, after approval is granted, after 2 years of residence, the tenant needs to submit a declaration form on its living condition and assets. For those who have resided for 10 years, they need to submit a declaration form under the well-off tenancy policies. And also the housing authority has obtained information from banks and public and private institutions to confirm these information. Now, failing to furnish these information will lead to suspension or eviction of tenancy. So in the bill, we have already provided for an offense for refusal to furnish or neglect to furnish any details specified in the declaration form under Section 25(4), and the penalty is 3 months imprisonment and a level 4 fine, $25,000. Now, for overseas assets, if there are complaints the Housing Authority will act on these complaints and obtain information from the relevant authorities. Now, in 2024 and 2025, we have confirmed that 26 households have failed to declare their properties in the mainland. So if the asset value exceeds the limits, we will issue a notice to quit. This applies to applicants on the waiting list as well. Now, there are also views that we should establish an online application platform or declaration platform. We already have such a platform. Existing account holders under the iHousing app can submit the declaration form online. Now, on false information or refusal to furnish information. Now, under Section 26(1) and 27(a) of the Ordinance, for providing false information or making a false statement or refusing to furnish information, the maximum penalty is a level 5 fine, $50,000, and 6 months imprisonment. And for level 4 fine, $25,000 and 3 months imprisonment, respectively. Now, the court will adjust the penalty case by case. Now, to enhance the deterrence of the offense, we have extended the prosecution limit for the above offenses under the wealth tenants policies to 6 years or 2 years after the commission of the offense or within 6 months after the discovery thereof by an authorized officer, whichever is the earliest. Now, in 2024, we have prosecuted 750 such cases. 630 were convicted and 40 are still pending. Among the cases, there were PRH tenants who were sentenced to 30 days imprisonment because they failed to declare local properties under their name. It serves as a warning to the public. We will continue to crack down on these behaviors to abuse public housing resources through prevention, inspection, and investigation. Now, whether we should apply the same requirements on non-residential premises, that is, commercial shops. Now, the Housing Authority already has a comprehensive system to manage shops. Ordinarily speaking, during the tenancy period, these premises cannot be sublet or alienated to other persons. Now, about the award for reporting abuse of public housing resources. Now, the scheme was launched on the 15th of January this year. Complaints can be made through various channels, and anonymity will be kept strictly. Now, so far, 700 cases are being followed up. We encourage citizens to actively participate in this scheme. Now, some members of the public are concerned about the public education and our internal training after the passage of the bill. We will step up our efforts on both. The bottom line is we need the public, especially PRH tenants, to understand the contents of the amendments clearly. So even after the passage of the bill, the amendments will only come into effect on the 31st of March next year for sufficient understanding by the public. Now, in the estates communication and also in the lobby of the buildings and also in the management office, we will put up posters to educate public housing unit residents on the understanding of the bill. We will also step up internal training to ensure smooth enforcement. Thank you. Members, any views on public submission and the administration's reply? There being none, we move on to the next business. Now, concerning the suggestions made on the 17th of April, that is the last meeting, and also the letter sent by the legal advisor, the government has submitted a reply. Now, a CSA will be submitted by the government in pursuance to members' views. Ms. Zhang, please. Thank you.
Based on the paper issued on the 7th of May,
we have listed out some follow-up items, and we will reply to each of these. Now, concerning the extension of prosecution time limit, now in the past, there were some cases which were not prosecuted because they have exceeded the prosecution time limit. Members inquired of the number of these cases. Now, since the Housing Authority does not keep record of these figures, we don't have this statistic. However, in December last year, we have discovered a case where in the 2020 round of tenants declaration, a household was suspected to have submitted false statements. However, when the case was discovered, the time limit has been passed. So we could only issue a notice to quit and take back the unit. Now, to enhance deterrence, we propose to expand the application scope of Section 25(4) of the Housing Ordinance on declaration of income and assets. So the applicable scope will extend beyond the tenants to their family members as well. So we will issue declaration form to the tenants based on this provision. And in the future, the new prosecution time limits will apply. That will become 6 years plus 1 year. Mr. Chen Haofeng, is that your question? Thank you, Chairman. I have some question about this. The last time we asked the administration for some figures, but the government is now saying that they don't have it. It's very difficult to prove the necessity of these amendments, if that's the case. If over so many years there is only one such case, it can't justify the change. You have been telling us that there had been many such cases. It's just that you don't have the number. That's not convincing. So can the government take a hard look at your record and give us the figure? Because otherwise we can't convince the public. Ms. Zhang, thank you. 2 points. There's definitely more than one case. The case in December past is just the most recent one we can find. There have been many cases where prosecution couldn't be made. Second, this amendment is not for trawling for past cases for prosecution. We are only targeting the offenses after 31st of March next year. Only those cases will be subject to a longer prosecution time limit. The amendment's major goal is to enhance the deterrence effect. So firstly, we have indeed discovered a lot of cases in the past. We didn't keep the statistic, but it doesn't mean that there is only one. Second, the major purpose is to enhance deterrence, but not for trawling up past cases. Dr. Wendy Hong, 4 minutes. Thank you, Chairman. 2 points seeking clarification. Now the scope will extend to the family members of the tenants. Does it mean family members residing together in the same housing unit? Second, the time limit will be extended to any time within 2 years next after the commission of the offence or within 6 months after the discovery of the offence, whichever period expires first. So why isn't it whichever is the later? Now, some tenants may be encouraged to run a risk and take the chance because of that. Thank you, Dr. Wendy Hong. First of all, your understanding is correct. There is a definition for family. That is the household residing in a unit in the estate, including a person whose name appears on the tenancy agreement and family members residing in the same housing unit. So for those people living in the same units but whose names are not on the contracts, they don't have to declare. Now, there are two factors in the prosecution proceedings. Now, first of all, six years after the commission of the offence or 1 year, within 1 year since the offence was discovered by an authorized officer, whichever is the earlier. Now, this is for the purpose to impose some time constraints on the investigating officers because we don't want the case to be dragged too long.
On the effect of extending the prosecution time limit, I remember in the last meeting, some members asked the following question. Say for some cases, the criminal act is committed after the 31st of March next year, that is, or before the 31st of March, what would happen? The longer prosecution time limit will apply to the following crimes, that is, the crime under Section 25, subsection 4, making false statements. Also, if you make false statements in respect of an application for a lease and also making false statements in relation to the purchase of subsidized sale flats, the longer time limit will apply. Say on the 31st of March next year, the bill comes into operation, then the longer prosecution time limit will also apply to the following offenses. And there is only one that is under the existing ordinance, that's Section 27A of the Housing Ordinance. The offense of refusal or neglect to furnish particulars specified in a requisition, it's a new offense. And illegal subletting or unauthorized letting, occupation or use of a PRH flat for trade or business, this is also going to be a new offense. There is only one existing offense under which the longer prosecution time limit applies, that is the offense of unlawful alienation, and it has a definite point of time for occurrence, and so it will not straddle the period before and after the commencement of the bill. So this is a concern raised by members in the last meeting, and after we've reviewed the bill, we believe that such situation won't happen after the passage of the bill. There was quite a long discussion about the long title of the bill in the last meeting. Some members were of the view that some wording is rather clumsy. So we think that we can make certain amendments to make the long title more concise. We will delete 一些 from the phrase in the Chinese text, and we will also accordingly delete certain from the phrase in the English version. Some members asked about the definition of trespasser in the last meeting. Under the existing housing ordinance, there's already mention about trespassers. Under Section 21, the housing authority has the right to evict trespassers. We are proposing to add Section 22A to the ordinance, so that when officers, when evicting a trespasser under Section 21, they can demand personal details from the trespasser. So the original interpretation of trespasser will apply to the bill. It is a commonly used term under common law. It means that person should not exist on the land in the estate. We will consider adding the definition of trespasser in the internal guidelines so that our officers have a better understanding of the definition. Under Section 25 bracket 3A, it is about definition of estate. Some members asked whether the estate only applies to public rental housing estates. This is correct, but we are incorporating members' views, and we will specify estate as any estate let for residential purposes, so that there won't be any misunderstanding about the definition. Same section, subsection 3A bracket B. Some members were concerned about the definition of member of the household of the tenant. As mentioned just now, there's a clear definition for a household in the existing ordinance. That is, in relation to a tenant under a lease of any land in an estate, includes the persons whose names are listed in the lease and who are allowed to occupy the land under the terms of the lease. If a family member is listed in the lease and can reside in the flat, then the person will be regarded as a household member or a family member of the tenant. Serious tenancy abuse concerns using a PRH unit for trade or business purposes. Under the IRO Inland Revenue Ordinance, the term carrying on business is used. So we are incorporating members' views to use this phrase in the bill. In terms of the definition of business, the one under the IRO may not apply to this bill because the definition is quite broad, but we will adopt the same phrase, that is carrying on business, in the bill. These are views raised by members in the previous meeting, and this is our reply. Any comments? So you've covered all the amendments. One is missing, that is clause 9. Well, why don't you cover it now? We are posing for CSA. We have covered 3 already. The 4th one is based on the comments made by the legal advisor. On paying fixed penalty. Apart from attaching the demand notice, we allow people to provide the demand notice number as well as the e-payment number. So this amendment is based on the comment made by the legal advisor. Legal advisor, any questions? Thank you, Chairman. We have looked at the CSAs and we don't have any questions about that. And you're happy with the government's reply? On the reply made by the government just now, I don't have any comment or issues. So, no other drafting or legal matters to be dealt with? Chairman, on legal and drafting issues, apart from the ones mentioned in our letter to the administration as well as those covered in the previous meeting, we did not notice any problems with with the drafting. Any other questions from members? If not, I'll see it as that we have concluded the scrutiny of the bill. The legal advisor would like the administration to go through your reply to his questions one by one. I'll ask Ms. Young to go through the reply. We actually covered the reply, but perhaps our reply was rather scattered. Our reply is in CB bracket 1744/2025 bracket 04. I'll now go through the reply one by one. On the commencement arrangement, there are 2 commencement days under this bill. There are 4 major directions under the bill. On empowering the Director of Housing to specify the forms for fixed penalty notice and demand notice, this can be implemented earlier. And on publicity work, we will have that come into operation on the 31st of March 2026. The legal advisor also asked about the tenant's household. The question is whether we will release any specified declaration forms. Yes, we will. And on the details of the declaration forms, we have enclosed the declaration form. You can see that under Part 7, there are parts to be filled out by tenants. And Part C and D, it's about declaration on asset and income. So there are guidelines for tenants and their family members. The legal advisor also asked about the defense for providing proof of identity. We confirm that this is a statutory defense and it encompasses the common law defense. The legal advisor also asked about the payment of fixed penalty. On the format, currently under the ordinance, the payment methods have been crossed out in the existing form. In future, how can we let payers know how they can pay the fixed penalty? We will list out the payment methods in the notices published in the Gazette. We will list out all the payment methods and we will add in faster payment system as one of the payment methods. Please hold on. The legal advisor has a comment.
Thank you, Chairman. On this point, I draw members' reference to Clause 13, brackets 4 and brackets 9 of the bill. Now, the Director of Housing can, by way of publishing on the Gazette, specify the form of the fixed penalty notice and the demand notice. Now, Gazette of notices are not subsidiary legislation. So whenever the form are amended in the future, the Legislative Council will not be consulted. So please clarify how the Director will amend the forms. Now, the reply mentioned a transitional arrangement. What about the long-term arrangement? Will reference be made to other existing ordinances? Thank you, Chairman. Now, under the existing ordinance, the payment methods are specified under Section 9, Brackets 1. There are 6 methods. These 6 methods will also be specified on the 2 forms which are going to be gazetted in the future. They are not mentioned in the bill. However, on Part 4 or Schedule 4 of the amended Cap 283, payment methods are spelled out. So this is also our policy intent. We don't want to attach the forms to the subsidiary legislation so that every time we need to amend the forms, we need to submit the forms for negative vetting by the Council. Any future changes will be published on the Gazette for expedience implementation. So my question is about the long-term arrangements of payment methods. Now, for the long-term method, we will refer to Section 9, Brackets 1. That includes paying the fine at counter, FPS, online payments, postal payments, and also payments by telephone. Now, if the legal advisor has no more questions, members, will you propose any amendments on the bill? Now, there being none, we have essentially completed our work. Now, when you have a date for resumption of second reading debate, please notify us because I think you have to work it out with the Council. Any other business? If not, thank you very much. Meeting's adjourned.